Means my learning friends met. The last item is much is my learning friends. Four 68 is my man.
468.
68 and 418. In order to appreciate the contents in order to appreciate these ethical laws and to find out what is wrong with the judgment, that I will place. First, we need to know what is the case of the petitioner. Here, let's make kindly come to the government's made.
You are opposite party in the red.
I am opposite party appellate.
In the red petition, you are opposite party.
Yes. So, the Lordship may come straight away. I have annexed the writ petition also in 468.
Give me a nutshell, what is the case of?
Well, the case is,
What they have made out, the other side has made out a case.
first, they didn't specifically challenge any promotion. They challenged two circulars issued by the Civil Tribe Department. This is not circular clarification. That clarification, they challenged on various grounds. That it is contrary to rule. The circular relates to definition of own clarification regarding own merit in section 3A of the criteria of promotion rules 99. Then they told that it is one contrary to the criteria of promotion rules. Then they say that the Civil Tribe Department is not competent and lacks jurisdiction because sections rule 6 of the said rule says that any interpretation regarding this rule would be prerogative of the GA department. Then the third thing they say that this is this has not got the sanction of the governor. That clarification letter has not got the sanction of the governor. So, and it amounts to a policy decision in contravention of the rules and decision, and therefore it is hit by 154 and 162 of the Constitution of India. And they relied on a case of this under court, which ultimately went to the apex court in person. But then the third point they asked is that by virtue of this, what has happened is that particular number of posts were advertised for advertisement. This is a promotional post where out of the total number of posts, particular numbers were marked to be filled up by unreserved category. Particular marks were filled up by Silukas and
Horizontal reservation in the promotional post.
promotion.
Yes, social reason.
In substance,
SCBC, SC, ST.
in a 1 minute, what is the case about? There are 148 newer vacancies earmarked for your people. 73 SC assistant engineers, those who are SC and ST, they have been promoted against your vacancies. 34 plus 18, SC and ST, they have been appointed against reserve quota, promoted against reserve quota. Their case is
These are the
these
cases.
73 these 73 SC assistant engineers being scheduled caste persons would not have been considered for unreserved vacancies. That is their case I have found on the top. Would not have been considered for your vacancies. Their consideration 73 scheduled caste against out of 148, 73 unreserved slot taken by SC is contrary to A.M. Nagaraj and Jarnal Singh saying that there is no quantifiable data. So they should be reverted back. In case of their reversion, with the scheduled caste who have availed reservation and promoted under reservation, they are to be adjusted against SC vacancies and ST vacancies respectively, and we should be reverted. Meaning thereby, a scheduled caste person appointed or promoted as a scheduled caste can never be appointed against your vacancy. That is what their contention is. So, question of applicability of M. Nagaraj and Jarnal Singh will fall for consideration. This is the essence of the case they have made out in the writ fiction. They are not saying.
Representing the candidate who is belongs to reserve category.
But
I am representing the candidates belonging to the reserve category, but in one of the cases, that is 468, I am telling that the entire judgment of the Honorable Single Judge is misconceived. Why I say that I was appointed in order to appreciate just for a glance. I have just given a 460 detail.
one sentence I missed out. They are not saying that the 73 persons have availed reservation and appointed. No, they are not saying this. They are saying 73 SC appointed against your vacancy. That's all.
Malad,
That is not there.
beg me, Lord, that without any intrusion from either of my friends from this side or that side, let me just go in a slow manner to understand. Because if the judgment of the Honorable Single Judge is allowed to stand, my Lord, to my mind, the entire service jurisprudence goes for a spin. Why I say that, I will explain. Has your Lordship got that 468? Just fast over one page.
I'm having.
What your Lordship says that there is no dispute. What your Lordship says, appellant number 1 in this case, though belongs to scheduled type, was appointed in the post of junior engineer on 19/5/1992 on regular basis.
So he's a scheduled tribe candidate, but in a regular means you are.
No. The initial appointment is not in the promotional post.
I am talking about the initial appointment. He was
Appointed in the year 1992.
the ST.
Yes, but it is not mentioned. For that, let me tell you, your Lordship. The mode of appointment then was, right from 1982, that a committee of chief engineers used to draw panels of engineers to fill up junior engineers, diploma and degree holder junior engineers, to fill up junior engineer post. And they used to prepare that panel year-wise and on the basis of the marks secured in the engineering exemption.
So there was no reserve post at the time of recruitment of a JE.
No,
there was no horizontal
Right.
observations
No.
given. Even SCS,
Detailed reserve post.
Say that is what I told you, when I think that God
Sir,
cannot-
no, you are.
then it will never be finished.
No, please, please.
Allow me, I will not take.
No, sir, please talk.
Not have undertaken like this, I think so.
No,
There should have been a horizontal observation, constitution or
No,
resolved by us in
I'm telling you, but just have a glance, 1992. And respondent number 428 read petitioner, appointment date, your lordship may kindly see.
88 and 89. 428.
428. They are 2014 on contractual basis they were appointed. They were regularized in 2020. As your lordship got. Then your lordship sees date of promotion to the rank of assistant engineers. But applicant number 1 was promoted
2013.
15/11/2013.
Yes.
Then respondent applicant number 2 was promoted
21.
30/12/21. Respondent number 4 to 8 were promoted on 21/10/2092. 22. And their serial in the gradation list was 35, 430, and the petitioners were 298, 297,
Fairly at the bottom. Fairly at the bottom.
Milord. So, then Milord, now they have to be promoted to the horizontal reservation will apply to persons appointed in the same year. Not, I was appointed in 1992, promoted in the year 2013 to the rank of assistant engineers. They get a promotion in 2022. Now they say that because I was a reserve candidate, I will not get further promotion as against some reserve vacancy. That is their case. Am I clear? So let's now go to what is their case in the writ application and what is their prayer. They don't challenge.
They said, according to you, they have simply challenged the two clarificatory notifications.
Notification.
SCST department, which according to them is not in conformity with Article 144, 154 and 162 of the Constitution of India.
And also Rule 3.
Because they cannot tinker with the rules framed by the government
166.
in such exercise
Rule 3.
Right.
by virtue of a
That's right.
notification.
That's right.
That's right.
And that is
I understood correctly.
Yes, rightly understood, Milo.
Right.
That clarification is in conformity with Rule 3 or not?
Rule
Your
not-
lordship will examine.
And in one case, they have challenged the promotion. Maybe.
In our case, they have challenged promotion.
When they filed, DPC was held, but promotion was not given. And subsequently, when the promotion was given in Water Resources Department, they have challenged in one case and prayed to pass that. I'll place both the prayers.
So I think the point which is involved in the incident repetition, if it appears to me, is a two twin grounds. One is relative to a notification issued by the SCS. You have to find whether they were competent authority to issue it, whether it invades or overrides any of this rules or the provisions contained
Of
in
the either of the recruitment rules or
the rules which is framed in exercise of the constitutional power.
309.
So whether that can be done, this is the one issue. Second issue is that whether the reserve category candidates can be adjusted under the UR category at the promotional stage.
Yes.
Or they should wait when the reserve
Yes.
But
They can be
right.
license in the promotion.
That is the
Right.
right.
They can be.
Right.
That is the correct. That is the point.
This is the.
That is the point.
Already 2 points. If one
Yes,
is just
absolutely
two
correct.
times.
Whether the case of Nagraj and General Singh will be quantified data will be necessary for filling up the unreserved vacancies. Because Honorable Singh Judge has blankly told that in cases of all promotion, doesn't matter whether it is for a reserve category or for general category, you must follow General Singh and Nagraj. So, I understand that General Singh Nagraj says that you have a quantifiable data in respect of reservation under 16(4)(a), that is reservation of scheduled caste, scheduled tribe with consequences thereafter or with consequences scheduled tribe. But it never says do you apply it in respect of general categories. That means general category becomes a category of reservation itself for the candidates who do not belong to scheduled castes and scheduled tribes. Am I clear?
No.
Then
Yes.
if you exclude all the scheduled castes and scheduled tribes who have avoid reservation, then only confine it to general category, then the general category becomes a reserved category, not for general people.
Yes.
And that is not the concept of reservation, and that is not the question of attracting any quantifiable data arises while filling up the general vacancy. So what is the dispute about in this case? A dispute regarding filling up the general vacancies. They never dispute. They say that you have included this candidate in the general vacancies. Exclude them, take them back to their respective category of scheduled caste and scheduled tribe, and promote the general candidate in the honor of seniority. But I need to tell your lordships that the right to be considered on the basis of greatest and best protects the right of a fundamental right, according to the other thing, replace those parameters. Then the question is whether the single judge committed, what is the clarification and what is the error committed by the single judge. So let's read the prayer first in order to understand whether my contention is correct or not.
No, that is based when you are arguing now then into dispute.
No, since there is a dispute regarding what is the issue about,
No. I believe the two issues they have not really.
No,
They are.
only one issue
Not,
can be added, one issue, whether reservation is permissible in Odisha so far as the promotion is concerned. That
that is always a different thing. That is another aspect of this matter.
all the aspects.
Whether reservation in promotional post will be available in respect of scheduled caste and scheduled tribes after the decision of the Nagraj. That is altogether different.
Single promotional post, then if it is a single promotional post.
But where is that? When it says that it must apply for all promotion. That is what single judge says. You are watching my kindly see. Yes. What is the question? That is at page 56, madam.
468.
460.
Page.
Page 56, running page.
Yes. Sir,
Blood. First is that those two subplots are set on their formula. Then say is to a read in the nature of mandamus or any of the direction directing the opposite party, more particularly the opposite party number one, take to consider the case of the prescription for promotion to the post of assistant executive engineer against the UR vacancies for
wanted them to be considered under the UR in terms of this Odisha Recruitment and Condition of Service Group.
Yes,
Engineering services.
yes.
That what?
So-
Two letters they have
So
challenged and.
they are challenged only two letters in this writ application.
And
And
also to be
subsequently,
considered for promotion.
that is right. Then what are those letters? Yeah. And I have is page 282, answer 11. First letter,
Sure.
11.
Page.
The writ application, 282. Writ appeal.
282.
Yes. 6-5, letter dated 6-5, 10, 11.
283.
That is letter dated 6-5-2024. Yes. The clarification, that letter reads,
6-4.
Anyway.
has already got it.
I got.
No, page marking,
Sir.
if the page marking is.
No.
I'll correct.
I got. Please continue.
But nothing is subject. Clarification on the concept of own merit in direct recruitment of the promotion. In inviting a reference to the subject mentioned above, and so that a clarification was sought from the law department. This was not issued on its own issue. The concept of own merit in promotion to the unreserved vacancy from amongst the reserved category candidates in the gradation list. The nursing will kindly see this mark that word in the gradation list. As you have noticed, what is then the law department, after taking into consideration the various case matters, has elucidated in detail the above point. The detailed views of the law department issued on 27/2/2024 is enclosed herewith for reference and necessary action of all department. Further, DOPT dated such and such has clarified that in the judgment dated 28/1/2022, in the case of Jarnal Singh and others versus Rastina Gupta and others, which currently holds the field, the Supreme Court has set out conditions that are to be satisfied by the government in order to implement the policy of reservation in promotion. The same has to be ensured before the DPC by all the departments for avoiding any illegal competition in the future. This is the letter. Then this, you are seeing next page, is the law department. Note sheet, which was endorsed to the Scheduled Caste Scheduled Tribe Department. So Scheduled Caste Scheduled Tribe Department has not expressed any opinion whatsoever regarding own merit and matter to be followed. Then when the Lord, it begins with 283. How it came to the law department? That administrative department has endorsed the file seeking views of this department to clarify the present status of own merit in direct recruitment oblique promotion in light of para 3 and 4 of the judgment rendered by Supreme Court in R.K. Savarwal and others versus State of Punjab and others. Has your also got? Then we'll have in next page. Then analyze Indra Sahni. Then R.K. Savarwal. Then Nagaraj, Jarnal Singh, everything, and then come to this conclusion. Reserve category employees as 286. First day you are not seeing notice to. Very day of admission of this. Thereafter that. In view of the above discussion, the following are emerged. Reserve category employees who have availed reservation in appointment and falling in seniority merit above the last unreserved candidate. Well, that is very important. Last unreserved candidate would be promoted against unreserved vacancy, treating them as own merit. Reserve category candidates appointed on their own merit can be considered for promotion and adjusted against the unreserved vacancies. Similarly, reserve category candidates who have availed reservation in appointment and falling in seniority above the last unreserved candidate would be promoted against unreserved vacancy. Senior reserve category candidates not appointed on their own merit in the gradation list would be considered in zone of consideration for unreserved vacancy. These are the 3 points that are given by the law department. Now, I have given that date of appointment and other things to show to it below. Let's assume for the time being, without going into the process of the recruitment, that I am a reserve category employee who has been appointed in the year 1992. Then I get promoted in 2013. Then the petition gets appointed on contractual basis in 2014, gets regularized in 2020. So both in the list of gradation list of junior engineer, by the time the petitioners gets appointed to the feeder cadre of junior engineers, I am already in the grade of assistant engineer. 1 year earlier. Then, therefore, I am senior to him in the gradation list of junior engineers, and 2013, if I get promoted, I will also figure above the persons the petitioners, even when they are promoted to the unreserved vacancies. So in 2013, I have been already been promoted and I've been working for last 7 years in that cadre before the regular appointment of the petitioner. And the petitioner gets promoted in 2022. Will my seniority of working in that cadre for 9 years will be wiped away because I have the reservation in promotion?
Entry level. Reservation at the entry level.
My appointment cannot be compared with you because you are not in that year. You are not born when I got promoted into the post of assistant. So that is the point that we are urging before you. Then, Lord, so everywhere the stress has been laid that figuring in the above the unreserved candidate in the relation list, the zone of consideration has you have to include it. So this the learning gives us find fault with paragraph 9 in paragraph 9(1) of the judgment. So that's my kindly answer to the judgment.
Put this law. Just forget, the single bench has started. Now you are in the court of appeal.
No, I am
Virtually at the first court of appeal.
yes.
So entire writ is at large.
Well,
As if we are hearing
I am telling, I cannot say that when I was just your Lordship kindly had what is missing below. One word is missing. Below paragraph 9, your Lordship kindly have the glance. Take the judgment, copy of good Khadi judgment. Only one not.
So it is here. You just tell me.
Paragraph 9 and 9(1).
Each at the bottom.
In my written piece.
No. Judgment page.
Judgment internal page.
No, I got it. Internal page 98. At the bottom right hand side, you will
Yes,
get a page.
yes.
Not at the top, at the bottom right hand side,
right.
page number of the judgment.
Yes, Mullah. At the bottom.
98.
9.
Nice.
Having-
Third learned counsel.
Appearing for the parties and considering the subject made, this court finds that eligibility of an employee to get the benefit of promotion in any cadre is provided under the OCS criteria for promotion rules 1992. This is not the eligibility, this is the method of selection. While amending Rule 3 of the 1992 rules, with insertion of Rule 3A, it was clearly provided that SC and ST candidates appointed on their own merit, either by direct recruitment or by promotion, and placed above the unreserved candidate in the merit list shall be considered and adjusted against the unreserved vacancies. And such candidates. And what has the view of the law that the court finds that on the face of such clear provision, opposite party number 3, while issuing the improved clarification of 6/5/2024 and 27/2/2025, not opposite party number 2 has not, basing on the view given by the law department, held that reserved category employees who have availed reservation in appointment would be promoted against unreserved to treat them as their own merit. What is missing is placed above the unreserved candidate. Now, am I clear? This has never been told by the Scheduled Caste Tribe Department. What the Scheduled Caste Tribe Department said? that follow the law departments as a guideline and also follow the latest law laid down by the Honorable Apex Court. And law department has told that person placed above in the gradation list above the unreserved candidate should be included in the zone of consideration earlier to the unreserved candidate, and they should be considered as against unreserved vacancies. But so this was this slide, that person placed above in the gradation list, this has been conveniently not reflected in the 9-1. Then, my lord, the next question is, your lordship sees that 9-2, he says, placing reliance on the provisions contained under Rule 6 of the 1992 rules. But let me draw your lordship's kind attention to the criteria of promotion rules. 1992. But prior to that, Rule 9 and 10 of the Orissa Engineering Service Rules is the recruitment and promotion rules. And Rule 10 mandates of the Orissa Engineering Service mandate that the BPC should take into consideration the OCS Zone of Consideration and Promotion Rules 1988 and the Orissa Civil Service Criteria for Selection for the Appointment and Promotion 2003, the Orissa Civil Services Criteria of Promotion Rules 1992, and the OCS Orissa Siruta Reservation Act and rules thereafter. May I place that Rule 9 and 10 of the recruitment and promotion rules? That is, given what else? But I don't see that. Let us place it from the book. Let me bring that. Say that. Also, no, Orissa,
In the writ petition, it is enclosed, isn't it? Is it not written?
huh?
In the writ petition, you have enclosed that.
They have enclosed this clause. The petitions, I don't think so. Is holding this, which one?
964, which is related to your assessment.
964. Yes, no. Right, sorry. Lord, that is at page 107 of the written. Why the committee, while considering the case of suitable officers and preparation of the list, had followed the provisions of the Orissa Civil Services Zone of Consideration for Promotion Rules 1988, Orissa Civil Services Criteria for Promotion Rules 1992, Orissa Civil Services Criteria for Selection for Appointment, including Promotion Rules 2003, and the Odisha Reservation of Vacancies in Post and Services for Scheduled Caste Tribe Act 1975, and the rules made thereunder wherever applicable.
Service,
2012 rules.
method of recruitment and traditional service rules, 2012.
Yes, sir.
That is at page 68 of the, page 68.
Of the
That starts at page 68 of the introduction.
yes, sir. Yes, ma'am.
Then you are referring to rule 10.
Rule 10.
Rule
Rule 9 deals with the promotion.
just that.
That is Constitution of Department of Promotion Committee.
Page 7.
As your my Lord Chief Justice has called.
Yes, part 4.
Yes, ma'am.
Part 4, that's.
Ma'am. Then next page is the Rule 10. That Odisha Civil Services Zone of Consideration for Promotion Rules 80, Odisha Civil Services Criteria Promotion Rules 1992, Odisha Civil Service Criteria for Selection for Appointment, including Promotion Rules 2002, the Odisha Reservation of Vacancies in Post and Services for Scheduled Caste and Scheduled Tribe Act 1975, and the rules made thereunder wherever is applicable. Now, let me take your message to those routes, relevant portion of those routes. I have got this to dictate. Page 260 of this book.
Zone of consideration of officers.
Consideration for Promotion Rules 1988. That is mandated that this should be taken.
3 rules. There are only 3 rules.
Yes. Then 3 Lord, zone of consideration. Except in cases where the provisions of the Odisha Reservation Vacancy and the rules framed thereunder are applicable, in every case promotion made by way of selection to any service or post of the state for which zone of has been prescribed in the relevant rules, such zone of consideration shall be 3 times the estimated number of vacancies meant to be filled up from the general category in such service post or post, notwithstanding anything to the contrary. This is one. Then, Lord, wherever this is, except in cases where the provisions of the Odisha Reservation and Vacancies Act and the under are applicable. But if now your Lordship has seen that the Odisha Reservation and Vacancies in Post and Services Act are applicable in case of promotion because that is the recruitment tool. Then, Lord, what would be the zone of consideration in such a case? that is appointment and promotion rules law. As you got it. Page 2, what is the civil services criteria for selection for appointment including promotion rules 2003. As you got it. Or the selection board or the selection committee, as the case may be, for the purpose of appointment by selection or promotion to any service post, shall prepare a list of persons of the feeder grade of that services post who are considered by them to be suitable for such appointment. The number of persons to be included in the list prepared under summary shall be 1.525 times of the number of vacancies anticipated in the promotion or pertaining to that. Then the provision of these rules shall have overriding effect, notwithstanding anything to the contrary condition in any other department. So this zone of consideration is to be from amongst the feeder grade. Then your nursing comes to Orissa Civil Services. Orissa Civil Services criteria for promotion rules 1992, which is the bone of contention of the judge. As you got it. As you also got.
Page number.
But
Your book, my book are same.
246.
Yes.
92 rules.
Yes.
That is, your Lancet first looks at rule 3. As you also got it. Notwithstanding anything contained in the recruitment rules, all promotion to the posts or grades of different services civil posts under the state government shall be made by selection. Selection for such promotion shall be made on the basis of merit and suitability in all respects, with due regard to seniority, and names of persons included shall be arranged in order of seniority in the feeder service order. Then they provided that any junior officer of exceptional merit and suitability may be assigned a place higher than his seniors. They were not concerned with that for the time being. Then your lordship sees C. In order to judge the suitability and official for promotion, the Odisha Public Service Commission, the Department of Promotion Committee, the Selection Commission, or Selection Board, as the case may be, shall scrutinize proceeding 5 available annual confidential character rolls and other documents, if any, having a bearing on the performance and conduct of all eligible officers, unless for reasons it is considered to refer to any earlier record. So, the only thing is evaluation of the CCR. Then, Rule 3A 248, this is not, has your got it? Next page.
There is no rule 3A.
And then it is old move.
The DA is inserted.
Yes, yes.
Ah,
2022 amendment.
In
That is
the-
one of the crux of the program.
Not you can take this one. I think the only thing we say. Can you also look to page 141 in the REIT application?
Photocopy of the rules are there.
Brief 141.
That is the amendment 2022.
REIT appeal
Ah.
468 at page 141. That is there.
That is there. As you would say, got it. Hmm. Notwithstanding anything contained in the relevant recruitment rules, where the promotion is to be considered as per the post-based reservation by way of replacement theory, the separate zone of consideration shall be applicable.
What is the meaning of this replacement theory?
Replacement theory is when it is post-place reservation, the roster, on a roster point, when it is post-place reservation, once that slot is exhausted by one particular category on his retirement, the same category person will fill up that. That is the replacement.
That means if somebody belongs to the ST category,
Yes.
then that promotional post which he was having for holding it, that can continue. Then the feeder post, only the ST candidates will be considered.
That as against that reserve.
No doubt about this. That's
Yeah.
RK
Provided
This
that.
is a very new word to me in a certain jurisprudence here. That's why I just.
right.
It flows from RK
This
Sabarwa.
replacement theory, I. was not
Post-based
aware.
reservation. Post-based.
Provided that.
Yes.
Now we are concerned with this. No,
Provision also.
The word is not used in RK Sabarwa.
that is not there.
That they say
Huh?
post-based reservation.
That is what is there. That's why I understand.
That's right.
Replacement word was.
No, that is not there.
That is not there in this order. I'll place our order for it. Provided that the scheduled caste or scheduled tribe candidates appointed under own merit, either by direct recruitment
Own merit.
or by promotion and placed above the unreserved candidate in the merit list shall be considered. So, under my humble submission of your lordship is that so far as the initial appointment is considered, there may be a written exemption via voice or some sort of process to find out the suitability. So, that merit will mean the merit list drawn up by the appointing committee. But when it is used either by direct recruitment or by promotion, and a promotion there is no
If there is two channel of recruitment in a particular post, then in that you can, yes, how to adjust it.
Right.
This is really a two channel. One by a direct recruitment, one by a promotion from the
Yes.
feeder post.
yes,
You know.
here it is also that is two channels. Then the unreserved candidates in the merit list shall be considered either by direct recruitment or by promotion.
That is 60-40.
That
50 by direct recruit, 40 by promotion.
That is there. It depends, somewhere 25, 75.
Yes, somewhere 50,
It all
somewhere.
depends.
Right. I think
or by promotion. But in cases of promotion, there is no recruitment test. The only test is what, Malak? Only test is evaluation of
TCR,
CCR.
and
that's
senior.
the only test.
No,
That is
senior,
the only test.
senior, senior.
With due regard to
There
senior.
is no seniority come merit.
Huh? No.
Nothing.
Here, lordship sees.
Seniority.
Merit is
In order
very
to-
wise. No written
In
test.
order to judge the suitability, In order to judge the suitability and officer for promotion, the Orissa Public Service Commission, the Departmental Promotion Committee, the Select or Selection Committee may be, shall scrutinize proceedings, five annual confidential character roles and other documents in order to have a bearing at thing. And all promotion service selection is on the basis of merit and suitability.
So how the merit is to be judged?
Sure, there is no, only merit has to be judged on the basis of the gradation.
At the seniority.
Seniority. So, when there is no written exemption or evaluation, then the question of merit will not arise now.
But then why this legislation include the word merit and suitability? These are the two expressions which are
Merit
used.
comes suitability with due regard to seniority.
Seniority and
Seniority is to be counted.
yes,
And then the merit and the suitability will also be taken in a parallel platform.
yes.
That has to be done in this way. So if somebody is equally meritorious,
Yes,
somebody
yes,
is equally
yes.
suitable, then
Then
definitely the
seniority. Yes, yes. That is
a very common
That is the uniform.
fundamental principle.
That is fundamental principles. That. But what is the merit in the promotion phase?
Only 5 years this year.
Nothing except that is provided. That if the 5 years CCR evaluation is or
The 92 criteria for promotion is different. This is so far as engineer case is concerned. Here we have clubbed up all multi-purpose health worker, junior revenue assistant to senior revenue assistant, then omit RI, various cases of tax. In that, when there are two batches, suppose that, just 1 second, when there are two batches, suppose 2014, 2016, how do you adjust the merit? That cannot be. They are not on a parallel base. So therefore, that is what is the mistake which has been committed.
I'm reading
I
that
will
rule.
place it,
I'm
my
reading
lords,
that
after my
criteria for promotion
correction.
rules. This says, notwithstanding anything contained in recruitment rules, all promotions to the post or grade of different services, civil post under the state government shall be made by selection. Selection for such promotion shall be made on the basis of merit and suitability in all respect with due regard to the seniority, and names of persons included in the select list shall be arranged in order of their seniority in the feeder grade service or grade. That's what your lordship was. Provided any junior officer of exceptional merit or suitability may be assigned in a place higher than his senior in such a place, assignment of higher position.
Now, if there is something that suitability you just it is good, but some junior person has got outstanding CCR.
Yes, sir. Say that how to judge the merit. One second. How to judge the merit, it is here.
Then that
In order to
provider will apply.
In order to judge suitability of an officer for promotion, Odisha Public Service Commission, the Departmental Promotion Committee, the Selection Committee or Selection Board, as the case may be, shall scrutinize preceding 5 available annual confidential character roll and other documents, if any, having a bearing on the performance and conduct of all eligible officers, unless for reasons to be recorded, it is considered necessary to refer to any earlier record to adjust the officer's suitability, provided available confidential character roll CCRs taken into consideration for promotion as above shall include CCRs covering at least period of 3 years in the preceding 5 months. So this is the merit cum suitability. There is no written, no bylaws, nothing of that sort. Only assess it, then decide.
No subjective satisfaction.
No. They are all already on record.
So now, my lord,
going on. So I think we should have a tea break for 5 minutes. No, Mr. Mahanti is agreeable for that.
Well, look, he pointed out that you are non-stop arguing, it is already close. To hello, we are holding their lordships back.
There's nothing.
Yes,
sir.
5 minutes, because this is not going to be over by another 10-15 minutes.
We should have it come back. Your Lordship.
But first time I think I learned there's so much concern over it.
I am concerned about Mr. Rautray.
Take your lordship back to the Orissa Civil Services Zone of Consideration for Promotion Rules 1988. Just may I have a glance for 1 minute. Otherwise, this Orissa says that you will take into consideration this zone of consideration in the Rule 10 will be redundant. I don't know. Basic. Has your lordship got it? Definition 2C. Electricity. Zone of consideration means
Most of the state is an improvement year.
In a recruitment zone in the gradation or seniority list of officers. In a particular
That is what you want. Recruitment year.
yes. So that placement of the seniority list is also a vital aspect. Gradation list and that particular recruitment year is also a vital thing. Then the next, this is the position. And what they did consider while considering that that is another rule, not the Reservation Act and rules. As late as Orissa reservation of vacancies in post and services for Scheduled Caste and Scheduled Tribe Act 1975. Much prior to Nagaraj, my lord. So it was in consonance with the Article 16(4). Your lordship may kindly see.
Volume का नहीं
It has the Odisha. Like not that.
हाँ next section
It has 8 page 848. Has your lordship got it? Then your lordship may kindly have a glance at section 4. Because the single judge has dealt with these things, I am passing along, but these points will be further elaborated by one offense because we have distributed the points so that we do not overlap each other. Section 4. Except as otherwise provided in this Act, the vacancies reserved for the Scheduled Caste and Scheduled Tribe shall not be filled up by candidates not belonging to the Scheduled Caste and Scheduled Tribes. This is a prohibition for others being considered for reserved post.
Obviously, that's the, otherwise it will disturb the fabric of this reservation.
Roster point.
That's the point. The reservation of vacancies, but not the vice versa. The
Merit is the criteria. Merit is the criteria.
Merit, yes. The reservation of vacancies in post and services shall be at such percentage of the total number of vacancies as the state government may from time to time by order determine. Has your lordship got it? Under this, the state government has passed an order exercising powers under Rule 4 with the concurrence of the governor. That is at page Notification types to proceed. Page code পড়েছে
Retaping on page 136. छोरा नंबर सप्लायर notification.
136.
हाँ.
Forwarding the other applications. That
Retaping is 440 है. Okay, and it's a pain content.
that is annexed the appeal. এটা কোনটা 440 at page 136. It says in exercise of the powers conferred by subsection 2 of section 4, which I placed of the filing.
Read appeal 440.
It appeal 440 and answer 2. Page 136.
You have copy? Yes.
That in exercise of the powers conferred by subsection 2 of section 4 of the Orissa Reservation of Vacancies of Post and Services for Scheduled Caste and Scheduled Tribe Act 1975 and suppression of the orders of the government of Orissa in the erstwhile Harijan and Tribal Welfare Department dated 15 February 1980, the state government do hereby determine that the reservation of vacancies in post and services in the case of initial recruitment as well as promotion for the scheduled caste shall be at 16.25% and for the scheduled tribe shall be 22.50% of the total number of vacancies by order of governor. So this is thank you. And this nobody has challenged as yet. So then, Lord, we come to the next finding that another point I will elucidate and leave the rest of the point to my learned friends. Another point is that the Honorable Single Judge says it is only the GA department which is competent to issue clarification on criteria under promotion rules 6. That your Lordship has seen. Now, your Lordship may see two documents with the page 292 of Annexure 15. Annexure 15 of the writ appeal of my writ appeal.
Oh, this is the same notification which you read.
Good. Annexure 15, page 292.
No,
Has your-
it's different.
That is dated 10th April 2023. This is by General Administration and Public Grievance Department. Has your lordship got it?
97
Clarification on zone of consideration and criteria for promotion for compliance of court order passed in favor of assistant engineer civil belonging to scheduled caste category of this department regarding that promotion to the rank of assistant executive engineer against unreserved vacancy on merit some seniority basis. Then they reiterate the same thing, that a person placed in the your lordship is 294 mila. Page 294. Has your lordship got it? Oh, that the zone of consideration will be on the basis of the gradation list. Then further stated, after rule 294 million, first paragraph your lordship omit. Further stated that after rule 3 of this criteria for promotion rule, 3A is in addition. In respect, the considered views of law department has been received as at which is reproduced below. It is mentioned here.
Yes, that was the law department, three categories.
Like that is in 2025. This is existing by the
Then relevant point of.
no, the GA department has issued this clarification based on the law department's opinion. So it is not a case that it is without jurisdiction and GA department has not taken. This document also will file before the under signatures. But this has not been dealt with. Then we are looks at rules of business. It says that scheduled caste department is not competent. As your lordship got it, it has the volume 7.
Volume 7.
Volume 7.
Page 851. 851.
May I place it? Your lordship says that this begins in exercise of the powers conferred by clause 3 of article 166 of the Constitution and in supersession of all previous rules made in this behalf, the governor will please to make the following. Rule 4. The business of the government shall be transacted in the departments specified in the first schedule and shall be classified and distributed between those departments and their branches as laid down therein. Now we have to look at the first schedule. That is the first schedule, serial number XIX. page 902. Got it? Then state subject, serial number 10. In the Orissa reservation vacancies in post and services for Sirutas and Sirutas and rules framed thereunder. So if the law department has been asked an opinion and the law department says that follow the Supreme Court decision laid down in General Singh and follow the opinion given by the law department. And which was existing earlier as late as 2023. Then how can you say that this is a letter without jurisdiction? First thing, he has not, because the Lord Siruta opposite party number 3 has found nothing. And the law department's opinion is misquoted by omitting that above the person placed above in the unreserved candidate in the gradation list. That part is not there. Then, my lord, the other findings is 9.2 is placing reliance on the provisions contained under Rule 6. Is that right? Then it says that Article 154 and 162 of the Constitution of India in Prasanna Kumar Sahu's case. Prasanna Kumar case, Sahu's case, that is at paragraph page 58 of the judgment. Paragraph 58 of the judgment. Page 58 of the judgment, paragraph 7.3. Has your lordship got it? The relevant para is paragraph 12. 7.3. Even a policy decision taken by the state in exercise of its jurisdiction under Article 162 of the Constitution of India would be subservient to the recruitment rules framed by the state, either in terms of legislative act or the proviso appended to Article 309 of the Constitution of India. So that was a case, a policy decision was taken contrary to the recruitment rules made under 309 of the Constitution of India. Here, there is no policy decision.
Yes.
So, where is the question of attracting this, my lord? Then, my lord, the next finding is that there is no quantifiable data. With all respect, my lord, I submit that so far as promotion to the unreserved category is considered, question of quantifiable data and applying the principles of Nagraj and General Singh is misplaced, and it is not applicable. So then, my lord, comes the question paragraph 9. Then your worship sees the finding in 9.4. 9.3 and 9.4 is 100 of the judgment.
That is what is it, that there is no attempt to have a quantifiable data.
In terms of so followed in since no has yet been followed with regard to inadequacy of reserve category in any cadre or post, so admitted before the so in the absence and by the state in any cadre and the owner, no such clarification could have been issued. The clarification doesn't relate to any promotion given, it relates to only a finding law. Then your lordship sees on single judge has held that three other decisions, Lalit Kumar Naik, Littu Behera, are per incurable. They were dealing with reservation in a promotion they are dealing with promotion as against unreserved category, and they have cited all these decisions and dealt with it. And even the honorable single judge who has passed this order has himself followed it. I have given a copy of that judgment earlier to your lordship. Then the last is 9.5. While passing clarification that as well as consequential action taken thereof by various government to follow the provisions contained under Rule 3 and so also the provisions contained under Article 16(4)(a) of the Constitution read with decision in case of Meghan with regard to promotion of SC and ST candidates not against reserved category with regard to promotion of SC and ST candidates in blank. That Nagaraj and this is now my God, I leave it to my interest to shred the other person. I have to only cite 3-4 judgments. I have given a compilation of the judgments and earlier given. देखिए compilation of judgments 27/4/2026 it has been filed.
Chapter judgment.
हैं? हैं?
Chapter judgment
आ गया
1, 2.
आ गया 3 announcement. We also make it clear at case of words. Yes, sir. At case of words, paragraph 3. Paragraph 3. Yes. Well, paragraph 2 has to be taken first to know what is the submission and challenge. On the above fact, the petitioners have challenged the reservation policy on several grounds, but Mr. Harish and counsel for the petitioner has confined his argument to the following percent. The objective of reservation is to provide adequate representation to the scheduled caste and scheduled tribe and backward classes in service, and as such, any mechanism provided to achieve that end must have nexus to the object sought to be achieved. The precise argument is that for working out the percentage of reservation of the promoting and appointees belonging to scheduled caste and scheduled backward classes, whether appointed against the general category post or against the reserve post, are to be counted. In other words, if more than 14% of the scheduled caste candidates are appointed, promoted in a cadre on their own merit seniority by competing with general category candidates, then the purpose of reservation in the said cadre having been achieved, the government instruction providing reservation would become inoperative. Once the post earmarked for the scheduled caste, scheduled tribe and backward class on the are fulfilled, the reservation is complete, roster cannot operate any further and it should be stopped. Any post falling vacant in a cadre thereafter is to be filled from the category reserve or general due to retirement, etc., whose members of the post fell vacant. Adverting to the first point, Mr. Salve and Mr. Rajiv Dhawan, Learned Counsel representing the petitioners, have contended that the total number of promotion appointments belonging to the reserve category in a cadre are to be counted to work out the prescribed percentage of reserve. According to that, Learned Counsel, that the reserve can take advantage of the reservation made in their favor till the reserve category can take advantage of the reservation in their favor till the representation in the service, including those appointed against general category, reaches the prescribed percentage. For working out the percentage, the promotee appointees belonging to reserve category in the service, whether on the reserve post or general, are to be counted. Support is sought from the judgment of such and such. Then the chief says the High Court passed the promotion order, last 2-3 lines from that paragraph, was the promotion on the ground that the cadre was already having more than 22% persons from the reserve category. We are of the view that the High Court in Joginder Singh Sethi case fell into a patent error. The said case was subsequently considered by a full bench of the Punjab and Haryana High Court in Jaswansi. Education, the full bench didn't agree with the decision in Joginder Singh Sethi's case and reversed the same. When a percentage of reservation is fixed in respect of a particular cadre and the roster indicates the reserve point, it has to be taken that the posts shown at the reserve points are to be filled from amongst the members of the reserve category, and the candidates belonging to the general categories are not entitled to be considered for the reserve post. On the other hand, the reserve category candidates can compete for the non-reserve post, and the event of their appointment to the said post, their number cannot be added and taken into consideration for working out the percentage of reservation. Article 16(4) of the Constitution permits the state government to make any provision for the reservation. That is that 16(4) I request that rule. So, it is categorical, my lord. Their lordship has held that whereas on the other hand can compete for the non-reserve post, and in the said post their number cannot be added. Then, my lord, I will take your lordship to Ajit Singh Jonathan.
The subsequent portion.
Subsequent person, I leave it to you. Then why but he's wrong if I place everything.
You have read the whole of
I am telling in a lighter way. But they have to place something.
justify their appearance as
Right. That they can't expect me to press all the heads and they will say nothing. Your Lordship, may kindly look at paragraph 22 of Ajit Singh Jonathan. Has your Lordship got it? May I please? Article 14 and Article 18. Has your Lordship got it? 22.
Yeah, one or two.
Yes. Is right to be considered from a promotion a fundamental right.
No doubt.
Article 14 and Article
Right to promotion.
that's right. Are close. Yes. Article 14 and Article 16(1) are closely connected. They deal with individual rights of the person. Article 14 demands that the state shall not deny to any person equality before the law or the equal protection of the law. Article 16(1) issues positive command that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. It has been held repeatedly by this court that clause 1 of Article 61 is a facet of Article 14 and it takes its roots from Article 14. The said clause particularizes the generality in Article 14 and identifies in a constitutional sense equality of opportunity in matters of employment and appointment to any office under the state. The word employment being wider, there is no difference takes within its scope the aspect of promotion to post above the stage of initial level of recruitment. Article 61 provides for every employee otherwise eligible for promotion comes within the zone of consideration. A fundamental right to be considered for promotion arises now. If this has then for promotion, which is his personal right. Promotion based on, then they elucidate further, promotion based on equal and seniority attached to such promotion are facets of fundamental rights under Article 16(1). So this is an emphasis laid down on seniority. Where promotional avenues are available, seniority becomes closely interlinked with the promotion, provided such a promotion is made after complying with the principle of equal opportunity stated in Article 16(1). For example, if the promotion is by rule of seniority cum suitability, the eligible seniors at the basic level as per seniority fixed at the table and who are within the zone of consideration must be first considered for promotion and be promoted if found suitable. In the promoted category, they have to count their seniority from the date of such promotion because they got promotion through a process of equal opportunity. Similarly, if the promotion from the basic level is by selection or merit or any rule involving consideration of merit, the senior who is eligible at the basic level has to be considered, and if found meritorious in comparison with others, he will have to be promoted first. If he is not found to be meritorious, the next in order of seniority is to be considered. Found as more meritorious than the seniority, he should be promoted in either case. The person who is first promoted will normally count his seniority from the date of such promotion. There are minor modifications in various services in the matter of counting seniority of such promotee, but in cases the senior must be the senior. That is how right to be considered from position and the seniority attached to such promotion becomes important facets of the fundamental right guaranteed under Article 16. Then order. अखिल भारतीय शोषित कर्मचारी संघ Then you look at paragraph 11. Contingency right is that is probably burgeoning nursing law is this. Thus, by the time a senior person belonging to the general category gets promoted to the higher grade, if the junior persons belonging to a reserve category who had been promoted to the said higher grade earlier, 11.
In appointment.
Thus, by the time
Seniority of merit, merit, merit.
has your
Last on your candidates.
Internal page 71 of that judgment. 71, right hand side it is given, page 71. Paragraph 11.
Yes.
अखिल भारतीय सूचित कर्मचारी 21. Thus, then what happens if a person, a junior person, on the basis of reservation, gets earlier.
There's a catch-up theory.
Thus, by the time a senior person belonging to the general category gets promoted to the higher grade, if the junior person belonging to a reserve category who had been promoted to said higher grade earlier has been promoted to a still higher grade, question of granting seniority to the general category in the upper promoted category could not arise. The general category candidates in the promoted category could not arise. This being the position and the promotion having been made as much prior to the judgment of this court in several other the tribunal was wholly rejecting over. That apart, in a particular cadre, after following the roster meant for reserve category candidates, there is absolutely no bar for filling up the vacancy in the general category, even in favor of a candidate belonging to the reserve category, if the said reserve category is entitled to serve on the basis of his general seniority. Then General Singh now, that Lapinan Gupta, this is 2022. Then Supreme Court.
ଆପଣଙ୍କ ପାଇଁ ଚିନ୍ତା କରୁଛୁ ଆମେ 2 ଦିନର ଫିସ୍ ଆପଣ ପାଇଛୁ 2 ଦିନର ଫିସ୍ ପାଇଛୁ ଆପଣ ପାଇଁ ଚିନ୍ତା ଆପଣ ପାଇଁ ଫାର୍ଷ୍ଟ ହାଫ୍ ସେକେଣ୍ଡ ହାଫ୍ ମୋ ଭାଇ ପାଇଲେ ମୁଁ
Paragraph 19.
ଆମକୁ କେତେ 25,000 ମିଳୁ ଆପଣ 3 ଲକ୍ଷ ଲେଖା ନେଉଛନ୍ତି
That is paragraph 18 onwards may submit. Seniority, as you have got, seniority of superintending engineers in the irrigation department of the state of Punjab was the subject matter of a writ petition filed under Article 32 of the Constitution in Ake Savarwar versus State of Punjab. The relevant instruction issued by the state of Punjab provided for 14% reservation for SC. 2 points came up for consideration before this court in the said judgment. The first being that in case of more than 40% students are appointed, promoted in a cadre on their own merit seniority, then the purpose of reservation having been achieved in the said case, the government instruction providing reservation would become inoperative. The second point on which argument was heard is that roster cannot operate once 2 points earmarked for the SCN are filled up. Any post filling vacant in a cadre thereafter it will filled from among the category reserved or general during the retirement of those number in posting. In the first point raised by the general category candidate was rejected by this court by holding that reserve category candidates can compete for non-reserved posts and in the event of their appointment to the said post, their numbers cannot be added or taken into consideration for working out the percentage of the reservation. Then this means till 2022, the court has approved at case our one. And my London Mr. Mukherjee will place me on. Then in all those cases, they declared per interim, Savarwal has been followed. So I leave it to my advantage. And oblige.
Next maximum.
Any new to what chief has argued?
Well, I'll take your assist without repeating what my senior friend has already argued about the factual aspect of the matter, how we are affected, in fact. If your worship kindly turn to Annexure 12, that writ application, my writ application.
Appeal 4%.
Page 89 of that WPC 19884 of 2025.
It appeal 440.
Can I be permitted to, but 5 minutes.
But this 9/7/2025 Annexure 12 is also subject matter of challenge. In pursuance to the recommendation of the DPC, held on 26/6/2025, the following 200 assistant engineers civil, that within bracket is important now. Unreserved 148, SC 34 and ST 18 of the department are hereby promoted to the rank of assistant executive engineer. This is the subject matter of challenge. This 148 includes 73. That 73 are the clients of Mr. Mahanti Maran. They have been promoted in the unreserved category, and that's the reason why their allegation is we are coming within the restore. So far as my clients are concerned, then they come within the purview of SC 34 and ST 18. So they say if they are to be considered on SCSS category, then I will go down. Otherwise, I am junior to them, petitioners. Therefore, my promotion depends on these 73 candidates for sure. 73 candidates future, if they are accepted, that they can be considered on unreserved category, because they were promoted, initial appointment on merit cum seniority. And they have been appointed in unreserved post or reserved post. That's a different matter because they have been appointed much before. When the petitioners came to picture as assistant engineer, they are much later than those persons who were junior engineer and thereafter assistant engineer. That was not the subject matter of dispute. At the time of promotion, question is whether they will be deprived to be considered on merit, that means on the basis of seniority and their CCR, to be posted as senior to them and be on reserve category. Why clear? But page 21, sorry, para 21 of my counter affidavit to the rate, kindly see. So in my writ application, though the petitioner challenged the appointment of 73 candidates, they have not been imputed as party. Am I clear about it? They challenge that, but they have not made parties here. That I have indicated here, that petitioners have not arrayed 73 candidates against whom it is alleged that they have been illegally included in the election.
As a plea of demo, we will definitely consider now and we still we are there. Whether that plea was taken or not, I do not know.
But it has been taken well. It has
Plea of demo was decided by.
Sir, what has happened here, the Honorable Single Judge took up one matter as the lead case and heard the argument.
That is why we wanted this.
It has been decided, but these are all points taken in the counter affidavit.
The bar has taken responsible for this. We have been seeing many times mentioned this, they have tagged this matter with this, tagged this matter with this.
Yes, yes.
They're tagging
But exactly that has happened here.
For a Casper, that everything is tagged. So that will avoid this situation.
See, the admission stage has been disposed of, all cases are disposed of.
I understand. The.
But what I want to do,
It's still, grappling to fathom that, what really, it talks about. According to the argument of the senior advocate.
yes,
That are. It says that even you are there in a unreserved category.
right.
Consideration if you are at the higher position. Then, particular category. You may also be considered on the ground of a senior.
So why I wanted to show this paragraph is not for the 73 persons. I wanted to show my position so far as the serial list is concerned, which is below the petitioners. So far as the promotional list is concerned. I have given the details of it. 9248 Annexure 12, serial number 126 to 140 in the reserve category. Already it has been specifically mentioned here. And my position has been clarified. 6, 7, 8, 9, 10, they have been included in the reserve category. That is, I have to indicate that. But my inclusion in the reserve category is as per the schedule that has already been fixed for the reserve category in that Annexure 3 of my REIT agreement. That document has been shown that the reservation of vacancies act in the rules from there under.
Promotional stage.
Yes,
There is also a reserve category post.
for promotion.
You were accommodated in the reserve.
In the reserve category, I am a reserve candidate. I am accommodated in the reserve category. That is exactly I wanted to bring a lot of notice.
And they cannot have a grievance because they are general candidates, they cannot come to your category.
No. Sir,
Obviously. that's
obviously,
two fundamental.
exactly.
That,
So I am a reserve candidate. I have been considered in the reserve category.
person cannot claim any reserve category. Two fundamental.
Yes.
So that is within that category I have been selected. But let's kindly look at 92 rules again for the purpose of the legal proposition that has been advanced. Kindly look at 92 rules. That is in the REIT application that is also annexed.
No, it's there. What is yours?
In the REIT that has been exhibited. The REIT application.
Yes. Like two.
92 rules. Section rule 3, let's kindly say first. Odisha Civil Service Criteria for Promotion Rules 1992. Rule 3, let's notwithstanding anything contained in this recruitment rules, all promotions to the post of grades of different service civil posts of the state government can be made by selection. B, it says selection for such promotion shall be made on the basis of merit and suitability. in all respect with due regard to seniority, and the names of persons included in the select list shall be arranged in order of seniority in the feeder service or grade. So gradation list has been prepared for them. In the gradation list, the petitioners or the client of Mr. Mahanti are higher up.
That is
The proviso says there can only be a departure as per the proviso that if any junior officer of exceptional merit and suitability may be assigned to a place of higher than his senior, in such case the assignment or higher position to the juniors officers shall be limited to the same batch or year or allotment, except where an officer of the earlier batch or year allotment is found unsuitable for promotion. This is not the case here. Therefore, keeping in view of this rule 3, they are placed in the cadre as senior. They are appointed earlier. So at the time of consideration of promotion, they had to see the merit and suitability. And merit of suitability in these cases can only be seen by CCR. Therefore, they have been promoted. So therefore, those 73 candidates, promotion is based on section 3, rule 3 of this 92 rules. Now, this amendment that has been undertaken, if you kindly see, 3A, the further clarifies the position that notwithstanding anything contained in the relevant recruitment rule, where the promotion is to be considered as per the post-based reservation by way of replacement of theory by separate zone of consideration shall be applicable, provided that the scheduled caste or scheduled tribe candidates appointed on their own merit, either by direct recruitment or by promotion, and placed above unreserved candidates in the merit list shall be considered. Here actually, if you also look at by their own merit, either by direct recruitment or by promotion, well, they have been directly recruited, number one. Number two, this candidate, 73 candidates.
Okay.
And they are also promoted much prior to them.
no, on their own merit.
You have not been promoted.
I have been promoted.
Now you have been rewarded again. But you were below their
Sir, so my position depends. If those 73 candidates will be considered in the reserve category, then the reserve category I'll go down. I may not get a chance.
Waiting the reservation, they have been.
So that is, you are apprehending or.
No, I haven't done, my lord.
That you made.
So by virtue of the subsequent order, I have been taken out.
No,
I have been affected directly.
they have filed the petition.
Am I clear, my lord?
No, I understood. I understood.
If the
You have
70,
adjusted against the reserve category.
yes.
Then in that event, you will.
So if 73 will be considered in the reserve category, then I will not be considered.
It may go in a D scale down.
Yes.
Already gone. Already gone. Already gone.
Already-
Staying on the surface of the water.
Correct.
Already gone protected.
So my position is like that. So here in the instant case, 3A clearly provides.
All reservations through there.
Yes.
3A clearly provides and protects what are to be considered.
Senior.
And those 73 candidates were considered in view of 3A, which is in consonance with HON'BLE's case.
Yes.
But if you also kindly turn to those two circulars or clarifications, not circulars, clarifications issued, and the law department clarifications, kindly look to that.
He has already pledged.
Yes, what I beg to submit, but the opinion is the law department. Opinion, as you said, is an opinion. If it is contrary to law, it is on. It cannot be accepted. Clarifications only after the opinion was given on the basis of the opinion. The clarification doesn't speak anything else. He says law department has given an opinion. You follow it and follow the law. It doesn't say follow it strictly and so. It says follow it in consonance with law. That means Somerville's case. Or even journal case to that extent. They are not served anything else. So it is not something which is contrary to law. And it is not a policy decision or a executive instruction. Not that, sir. This is only a clarificatory letter on the basis of the opinion. If the opinion is, what is that opinion, Lord? The 3 essays on merit, philosophy was sent it on its own merit. So they wanted to clarify that position. But we kindly look at the 92 rules. Again, rule 6 and rule 7. They have taken an objection to that extent. So rule 6 says,
Has the government, in case of any ambiguity or.
GA department. But sir, if any doubt arises on interpretation, why clear not? But kindly look at 7. Issue of instruction, the government may issue
That
instruction.
power is given. We can give to instructions, so it has a statutory favor.
So what I beg to submit, this is not interpretation. There is no question of any interpretation. If any doubt arises with regard to interpretation, question of GA department comes into picture.
GA department 23 they clarified করছে না
And GA department also clarified that notification has been filed by Mr. Mukherjee, I think.
place কর 23
Page 137, let's you can see. Page 137.
Complete. Or read a bill.
Written. Yes, ma'am.
Read a bill. Yes. That has been placed before us.
Yes,
Serial number 2 and serial number.
yes. I don't want to place it again. What I say, the GA department has also given a clarification. Sir,
এটা প্লেস হয়ে যাচ্ছে স্যার প্লেস করতে
my senior friend has already. Again, and that's what I say.
Speaking in Odia.
Already.
I think
Sir, the manner in which the clarifications were issued since 97, the same thing has been repeated. Since 97, different departments have given clarification on the subject itself. There is no new thing that has come out. So this clarification doesn't change the scenario itself. What I beg to submit is 3A has been followed and Somerville has been followed. And this context, if the unreserved category persons can be considered in the reserved category, can be considered in the reserved category, no quantifiable data is required. Quantifiable data is required, where actually you want to increase or decrease the percentage of reservation as has been granted in 94 notification. So law says it can be more than 50%. In the Krishnamurti judgment, which has been followed, our Orissa High Court judgment also is there, that you cannot exceed 50%. If any quantifiable data is collected, it is required in a particular area, then it can increase or decrease subject to that availability of quantifiable data. We are not concerned about those quantifiable data here. The argument that was advanced by putting the unreserved category into reserved category into unreserved category without any quantifiable data is per se illegal. I think that argument doesn't sustain itself. The Honorable Court accepted it, single judge, but I don't think this is required at this in these matters to be considered for the purpose of quantifiable data. The only thing that is required to be seen whether the 73 persons are actually on their own merit has been taken and they can be considered in the unreserved position because of their seniority, merit, suitability.
What do we have to? I'm putting a question. I wonder upon and they think about it.
Okay. What I beg to sorry for also is that the petitioners have not alleged or made any statement in the writ application which are the reservation of seats by the government on the civil caste and civil trial candidates as per 94 notification has exceeded. And if it has,
Percentage.
yes, ma'am. That it has exceeded, in that view, the matter, if it has exceeds, there must be a 0.5 would have. The government has acted while effecting permission because that notification speaks about permission also. So our permission, here the rate petition, the rate appeal petitioners cases that they have been absorbed in the reserved quota as permission under law, as per the requirement, as notified by the government. Once we have been appointed there on the basis of our seniority in the gradation list, that should not be disturbed. Now, by virtue of the other rate application, they are trying to upset everything. Because now the revised order that has been passed, which are also of state, we have been taken out from it. All of them, Luxton and Barrel, has been taken out of the and reverted back to the original position. Assistant engineer. So our position should not be disturbed because they have not challenged it. Therefore, the question of 25 doesn't arise. The appointment of those 73 persons, assistant engineer, as assistant executive engineer, that they have been appointed or promoted on their own merit, has not been considered by the court. If it is accepted that they have been promoted on their own merit, as per Justice Overall's judgment, as per 3 capital A of these 92 rules, it should not be counted in the reserve quota of scheduled caste and tribe. And if that is not counted, our appointment is not going to be affected. Such a finding by the single judge is not there. But Honorable Single Judge has proceeded the matter because of the grounds on which actually they have challenged in the writ application. So what they have challenged, they challenged that 6/5/24 opinion of the law department. They have challenged the 2 other circulars issued 27/24 and 6/5/24. and 16324. Yes. Those two circulars were challenged to be contrary to Article 154 and 162. The department has no legal authority. It has already been argued that 154, the executive power of the state, 162, how the executive power is to be executed in past and what is the effect of it. This is not a case where an executive instruction or a policy decision has been made under Article read with 154 and with 162. So therefore that question doesn't arise. Second thing is competence of the Civil Consultative Department. You know, we have seen this, the rules of business of the government, that itself shows in the category of Civil Consultative Department, serial number 10 specifically authorizes the
State subject.
state subject. So therefore, this is one of the ground on which actually the Honorable Court has set aside the circuit. Number two ground that has been taken is that the 6524 violates the Model Code of Conduct. However, no finding has been given.
No.
And the third point that has been raised is the 92 rule provides a clarification of Rule 6. So this clarification has been issued contrary to because this department doesn't have the authority. So bereft of those clarifications, question arises, Rule 3, Railway 3A has to be considered if a person ability on merit and seniority. And seniority and merit. The zone of consideration is the cadre and the seniority. But 88 rule matter, which speaks about the zone of consideration. Therefore, here the authorities, the department, have considered their case on the question of seniority and merit. Merit in the sense the CCR have been examined as per 92 rule. And they have been found to be suitable and eligible to be promoted. And since they are senior to those persons who are challenged in the writ application, batch of writ application, so their case has been considered. So those things have not been considered by the Honorable Single Judge. By setting aside the order, the entire thing goes on. So my respectful submission will be made. But if you also looks at Savaral's case and General Singh's case, which also supports and confirms it, question of 25 data in present case doesn't arise. That question doesn't arise. Because they have raised that question, Honorable Court has proceeded on that matter saying that as if it has exceeded the permissible limit of reservation. And this is not a case of beyond the permissible limit of reservation. If your lordship turns to paragraph 9.1 and 2 of the judgment itself.
That was placed by the senior.
Yes, yes.
That was placed.
These are all things that have been dealt with, and they have eventually what the Honorable Court has come to a conclusion that Litu Behra's case and the
This pronounced out this is per incurium and you have to follow Nagraj and the another.
Because of quantifiable data, those
So according to you, when the
incurium.
rules, according to you, when the rules are very clear and categorical,
Yes,
that it has to be followed in the order of the seniority,
correct.
in the gradation. Once the seniority has been considered and they are found to be suitable,
Suitable.
that is one of the facet of the merit. So if they are found on merit in
Right.
that sense, then the question of any quantifiable data does not arise.
Doesn't arise because it doesn't exceed the permissible limit of reservation.
That is your.
It doesn't exceed permissible limit of reservation.
Yes.
Therefore, question of affecting my promotion, which is within the permission limit of reservation, should not have been interfered. I have not transgraded it. I have not superseded anybody. But I have been promoted in my own right as a reserve candidate in the reserve vacancies. And reserve vacancies are specifically earmarked.
Yes.
So that is exactly my point, sir. I have also given a written note. I think your worship must be having a copy of it. And I have also given the series of decisions which my senior friend also relied. Savaral's part of 4 also itself clarifies the position. Government has got the authority to do it. The question your lordship asked me just before rising murder, that has been answered in a 2010 notification of the central government in the SCSC department. There they say if a person has got reserve, appointed in the reserve vacancy and has been promoted, the subsequent promotion, he cannot be denied to avail the reservation. The fact question here actually may not arise. The 2002 notification is there. Paragraph 22.4, if there is a commitment, I can read it. I'll give a copy of it. ACSC candidate appointed on their own merit by direct recruitment or promotion and adjusted against unreserved points.
That is a different aspect.
Yes.
Probably you could not get the question.
Correct.
That is a different, there is no difficulty because that was not his act or a voluntary act.
Yes.
That was by virtue of his merit. The employer or the authority has put him into that category.
Correct.
But he does not abandon his status as a SCSC.
Yes.
He does not abandon.
Yes.
Then he can definitely offer that I, being an SCSC candidate, I must be
Yes.
given an
That's
option.
permission.
That is a different. If the position is reverse or somehow different.
So here what has happened, well, they have been considered on merit and seniority. And this aspect has not been dealt with by the Honorable Singh.
Let us see. Let us see.
And those judgments declining to judges per inquiry on this ground actually not permissible under law. The Supreme Court has said the rule of law prudence requires that he should refer to matter to a larger bench.
No, the parinthurium theory is already there.
Yes.
If the judgment appears to be a parinthurium having unnoticed the binding judgment on it, the court can, or if it is contrary to the statute also.
Yes.
This provision of the statute is not taken into
Take into
consideration.
consideration. Correct.
That can also be one of the ground of parinthurium.
Here that question doesn't arise. In that case also they have been considered on merit.
Yes. Anything more?
Yes.
That I will. The second that certain persons are below the giving the serial number in the gradation below the petitioners. But they have been appointed as against reserve.
Reserve post. That is what Mr.
And that is what
Vishnu, that is the same case of
that
Mr.
is what
Vishnu.
I wanted to point out, and I want to point out paragraph 13 of the writ application, out of which my appeal arises, where they admit that we are placed above them in the gradation. Okay. Running page 53 of the writ appeal in WA number 468 of 2026. Because that is the improved notification that is given effect to while considering the case of the petitioner for promotion to the next higher post, then certainly the case of the petitioner will not be considered as the reserve category candidates will be promoted against the post earmarked for your category, whose name found place earlier in the gradation list than the present election.
Subject. State subject is the department of your line.
Lost 22 election over 9 and central government notification. Can you just one, you can see that 20 to 1.
Yes.
Okay, I am appearing in two appeals. That's
Any additional points or any additional facts?
yes, but the additional facts was, in fact, I had first showed to your lordship that one of the petitions, the petitioners did not even have a cause of action, and they came up before the court, and their writ petition has been allowed. And it's, that is writ appeal number number 33.
446.
606 of 2026.
446.
606 of 2026, your lordship may take first. That I'll show the facts in both the cases. 606 of 2026, that's Bhagwat Maji and others. This is Alok Maharana.
What do you want to refer to?
Well, it's in this case, the petitioners, this is a case where they seek promotion from the post of assistant section officer to section officer in the home department. They are guided by the Odisha Secretariat rules. That is 2016 Odisha Secretariat rule.
This is a